Banks, the state of Texas.
For the defense, are you Sean Branch?
Yes, ma'am.
All right, you entered a plea on May 11th to aggravated sexual assault of a child. You entered a plea of guilty. According to the plea bargaining agreement, punishment is to be assessed at a cap of 20 years. The state is opposing your application and there's to be no contact with the complainant. Have both parties had a chance to review the PSI report, state? Defense? Any objection? All right, any witnesses?
Just Mr. Branch, maybe want to say something to the court, but I have some things to put on the record.
All right, Mr. Branch, if you would like to say anything to the court, you'll be placed under oath and the state will have a chance to cross-examine you. So do you wish to say anything?
The reason the state is opposed is this wasn't just a one-time incident. It happened multiple times. There's a confession in this case. When questioned by the detective, Mr. Branch told the detective that the complainant let him know that she had previously been sexually abused and that she would touch him in different ways and basically that she was coming on to him. State's argument is that's no excuse. The defendant should have told the complainant that he's an adult and that the way she's acting is not the right way to act with adults and taking the lead and made her understand that the right way that adults should behave around children. Instead of that, the defendant took advantage of the complainant and had sex with her in various ways, oral sex, and for that reason, the state is asking for you to sentence the defendant to 20 years TDC.
All right, defense.
Again, those are all reasons why Mr. Branch pled guilty and guilty as opposed to no contest. He knows he's responsible. He knows what he should have done. He knows what he didn't do that he should have done, and so he pled guilty. Fact is, this man has no prior contact with justice. He served 8 years in the U.S. Army, deployed twice to Iraq as infantry and field artillery. And he has no excuse for what he did, which is why he pled guilty. And this is not offering him background as an excuse, but as potential mitigation of punishment, which the law allows. We have ranges of punishment for these things, especially a first degree 5 to 99 or life, for a reason. And if anybody should maybe qualify for probation in such a case, among other people who may have such a case and worse record, Branch, simply because he's never had contact with the justice system before. And so we're asking that you give him that chance. Judge, how rigorous, from both your experience as a defense attorney, prosecutor, and judge, how rigorous sex offender probation is. It's not a walk in the park by any stretch. And again, other than these incidents, he's got no other issues in the past. So we're hoping that the court might see it that way. But if not, we're asking the court if you consider at least imposing something lower than the cap.
All right. So my understanding from reviewing things, if my math is incorrect, let me know that it's incorrect. But from what I can see, she was 12. Am I reading this incorrectly?
It's the state's understanding.
Because it's alleged to have happened on or about, and the date of birth is 2004. So she's either 12 or 13.
Stands to reason that's what made it aggravated as opposed to the use of force or a weapon.
No, I'm just trying to figure out the age. All right. Is there anything else?
I don't believe so. Do you have anything else?
Nothing on the state.
All right. Court will find you guilty. And I understand your service to our country, Mr. Branch. And I understand what you're saying happened. And I reviewed everything. And I understand that you did enter your confession to the police and you pled guilty to the court. The court will find you guilty. The court will sentence you to 20 years in the prison. There's to be no contact with the complainant, Chapter 62 registration, and credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal.
Yes, ma'am.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Branch, I will tell you, I do recognize and appreciate the fact that you decided to enter a plea of guilty. The fact that you owned up to what you did and that you know it was wrong. All right. Good luck to you.
Thank you, ma'am.
You're welcome. All right. You entered a plea of no contest on April 25th. There was sufficient evidence to find you guilty. The court ordered a PSI. According to the plea bargain agreement, there's no application for deferred adjudication. The state opposes your application for community supervision. Punishment is to be assessed at 3 years in the prison. It's to run concurrent with County Court Cause number 689077. And they will take in consideration County Court Cause number 699697. And the offense is unlawfully carrying a weapon with a felony conviction. All right, have both parties had a chance to review the PSI report, state?
Yes, sir.
Defense? Any objections to the PSI report, state?
No, sir.
Defense?
No, yeah.
Defense, do you have any witnesses?
Yes, I'd like to have the defendant speak, and I would like to speak on his behalf.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand, state your name for the record.
Michael Williams.
You're gonna have to speak up.
Michael Williams.
All right, defense?
Okay. Michael, you know that you weren't supposed to be carrying a gun because of a prior conviction.
Yes, sir.
Okay. And what actually happened? You were on your way home from somewhere?
I was on my way home from my aunt's house and I ran into a female friend of mine. It was New Year.
Were you walking from your mother's house or from your aunt's house?
Yes, sir.
Okay. You went into a friend, a lady, a woman?
And she asked me to check her firearm for her.
She's going to what?
I guess she was going to go sell her firearm and she didn't know if it worked or not.
Okay.
So I checked it for her.
So was it loaded already?
Yes.
Okay, so how did you check it then?
I shot it in the air.
You what?
I shot it.
Shot it in the air. Okay, and that was the basis for your arrest?
The base for my arrest was, okay, so she had to leave and go to her parents' home. I was gonna take her firearm to the house for me and hold it for her. So the officer stopped me. Someone had called in the shot. The officer stopped me and told me he got a call. And he got me with unlawful carry.
What do you mean that the police had gotten a call about somebody firing a firearm?
Yes, sir.
Okay. All right, so you had you were gonna hold it for her?
Yes, sir. So
Okay.
she got
All
that
right,
to me.
all right. Yeah, I'd like you to consider this and from the fact that there wasn't that much malice in his carrying this, it was something that he hadn't expected.
Oh, just 1 second. State, do you have any questions?
Let's see, okay, all right.
State, any questions?
Yeah, sir, is it true that you were on probation for burglary of a vehicle second in this file?
Yes, sir.
And isn't it also true that you never reported the probation for that offense?
I had complications reporting. I did try to report, but I had problems with my phone and the Zoom.
Did you have to go in person?
No, sir. I did call and make an appointment, but I didn't make it.
And no further questions, I'd just like to speak on his behalf.
Yes.
Okay, Your Honor, I'd like to consider in the PSI where it shows that his upbringing was a problem. He had no help from his father. He was brought up by his aunt and his mother, but he had a lot of psychological problems and depression. And he only went through halfway through school. And then he was not very employable. So for the last 7 years, he'd been unemployed. And I think that idleness also set the scene for his drug addiction and alcohol. But he quit the alcohol in 2014, but he continued on some other drugs and he hasn't had those in the last 6 months.
All right, just 1 second, counsel. Here's your choice. I can give you probation, but you're going into inpatient treatment, or either I will sentence you to 2 years in prison. Now, they say that you have mental health issues and that they're recommending MIOF. MIOF is inpatient. Now, you can go to prison for 2 years, do your time, you're done, or either you can be on probation out of this court.
Recommend you go probation.
Well, no, counsel, this is what I would always tell my clients. I'm not the person who's going to be doing probation. He will. And he knows better than I do, better than you, and better than anyone else, whether or not he can successfully complete probation. So far, what I've seen in his history, he cannot complete probation. But I understand that there are mental health issues going on because in the possession case for his previous conviction, I saw that there was a transfer to MIOF. So you know yourself better than I do, better than your attorney does. Deputy Laura always tells everybody probation in this court is not easy. So your choice is, and there are only two choices. One, I can send you to prison, or two, you're going in inpatient treatment and you're going in MIOF. Either way, you're not going home today. So which do you choose?
I would say, due to my current addiction, I was on heroin. I would say I need a inpatient. I would like to take the probation.
Okay. All right, the court is going to sentence you to 3 years in the prison, suspended and probated for 8 years. There's to be regular reporting, the UA hotline. We can do a referral to felony drug court. That will be in custody. If he's not accepted in custody, I see here that they're recommending MIOF. That's what they have in there, that he's eligible for MIOF. So if not felony drug court, then MIOF. And then if MIOF is not going to, if felony drug court doesn't accept him and MIOF doesn't accept him, then we'll do SafeP. Proof of employment or SSI within 45 days of release. There's to be no employment as a home health care provider or with minors. Field visits, 1 time per month, 200 hours of community service restitution. Do you have any children?
Yes, ma'am.
What are their ages?
14, 13, and 11.
Are you in their life at all?
Not at this time.
That's either yes or no. Have you been an upstanding father in their life, someone they can look up to?
I have, not
How?
recently, but I have.
All right, there's going to be parenting classes. This to run concurrent with County Court Cause number 689077. Taking consideration 699697. And then there will be the UA hotline. Counsel, you're hitting the microphone.
Oh, I'm sorry.
The UA hotline until further notice. Probation, is there anything else he needs? Is there anything else you need for me to be successful? I'm sorry?
No, ma'am.
All right. And so the MIOF, the felony drug court and SafeP, that's to be done in custody.
You know, and I think he's going to need a lot of help with getting employment. He hasn't had any, and he has his psychological problems as well. So
When's the last time you had employment?
2008.
All right. So you haven't really been supporting your children. All right. And with regards to employment, there's to be no employment as a home health care provider or with minors. If you are planning to be in your children's life and be someone they can be proud of, you're going to have to do better. If you're not going to be in their life on a permanent basis and just breeze in and breeze out, then you need not be around them. You understand? Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you sign that? Did you review that with your attorney and did you understand it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
because this is a felony conviction. You're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right. Good luck to you.
All right, thank you.
You're welcome.
Thank you.
Here's the issue. I referred you to felony drug court, and I see that you say that you can't do it because it's too much to do, but they're recommending inpatient treatment for you. So either you're going into inpatient treatment, or if you don't want to do it, you can be revoked and go to prison.
Well, that wasn't an agreement with the attorney. The attorney, she and I, what I asked the attorney, Miss Christian, I said, well, the police officer, they beat me up. I went to the emergency room and I brought it to her attention. I said, well, since I got beat up, and she showed me the police report, the police officer said that I fell from a gazebo.
All right. So here's the thing, Mr. Boyd. I've been a defense attorney, and this is what I always would tell my clients. Sometimes when they would tell me that they've been injured by the police, I would tell them that may be a separate issue for you to file a civil suit, but that doesn't excuse a possession case. So you're here for possession of a controlled substance, penalty group 1 gram to 4 grams.
No.
According to the plea bargain agreement that you signed up for, they're going to take some items into consideration, which they did, which wasn't evading. And there's supposed to be a TAP evaluation. The TAP evaluation is a treatment alternative to incarceration program. Basically, what that is that someone discusses with you any addictions you have. And then what ends up happening is, based upon the answers that you've given, based upon your history, they make a determination of whether you should do inpatient treatment or outpatient treatment. I always send people who have drug issues to felony drug court. Well, not always. I'd say like 90% of the time, because it's a good program. You're telling me you do not want felony drug court. I've read your letter where you say you can't do it because it's taking too much time out of your life. So since you don't want to do felony drug court and you refuse that, then the next step for you is for inpatient treatment. So those are your options. You can either do inpatient treatment, or you can go to prison. So either way, you're going to be doing time. So do you want to do your time addressing your addiction issues, or do you just want to do your time as an inmate? It's completely up to you.
Well, from my understanding, I mean, my attorney said that I was going to be 5 years probation. She did not say that I was going to go to inpatient treatment.
All right. What do you think probation is?
And
And as part of probation, I have to give you conditions so that you will be successful at probation. For example, if you have a drug issue, what would I look like giving you probation and saying, good luck to you, thank you? Probation is more than, here's a sheet of paper saying you're on probation, go live your life and do whatever you want to do. Probation is, you're on probation, you have to report, you have to provide clean UAs, you have to go to inpatient treatment. Those are conditions of probation. So those are your choices, Mr. Boyd. You can, 1, go to inpatient treatment, 2, see if felony drug court will accept you back, or 3, go to prison. Those are your options.
so what if felony court doesn't accept me?
Oh, then you're going to do inpatient treatment or either go to prison.
That's crazy, man. I'm lucky to be alive today because same police officer harassed me twice in 2 weeks, beat me up, and I'm here because of this.
Well, here's the thing. Are you, unless you're saying with this case, police officers planted drugs on you, you are still guilty of possession, and those issues have to be addressed.
So does that give them the right to beat me up?
No, it does not. Here's the thing. What I'm trying to explain to you is there are 2 separate issues that you may have. 1 is you're on probation. I've given you conditions. 2, you say the police treated you badly. That's something that you handle on the civil suit. That's not something that you come to me and say, I don't want to go to inpatient treatment because the police officers beat me up. Is there anything else?
That's it. I mean, guess I have to go with the inpatient treatment.
All right. So you can do inpatient treatment, or either I can send you back to felony drug court. What do you wish?
I'll go back to felony drug court.
All right. Ms. Abrams, can you see if felony drug court will accept him back? And that's to happen while in custody. If they say no, then he's to go to inpatient treatment according to the TAP recommendations. All right, thank you.
Thank you.
2023 CR 0529 and 2023 CR 0531, State of Texas versus Ronald Rodriguez. Can I have parties announced for the record for the state?
Travis Banks, the state of Texas.
Defense?
Milton Butler representing Ronald Rodriguez.
And are you Ronald Rodriguez?
Yes, Your Honor.
And each of the cause numbers, I'm going to show you what's entitled Motion to Revoke Community Supervision. Did you review those documents with your attorney? Did you understand them?
Yes, Your Honor.
Are you the same Ronald Roland Rodriguez who was placed on community supervision in 2023 CR 0529 for the offense of assault family second offense on March 6, 2023 for a term of 8 years? Ronald Roland Rodriguez, who was placed on community supervision in 2023 CR 0531 for the offense of assault family choking strangulation on March 6, 2023 for a term of 8 years. Is that you?
Yes, Your Honor.
All right. Any objection to the state reading the allegation and the defendant answering true or not true in both motions? All right, state.
The allegation in both motions is violated condition number 25 on or about the 21st day of March 2023 in Bexar County, Texas. The defendant, Ronald Roland Rodriguez, defendant there directly or indirectly contact the victim and or the victim's family of his offense without the court's and or the supervision officer's authorization in violation of condition number 25.
How do you plead to that in each cause number? True or not true?
Sure.
Any objections to the state's waivers?
No objection.
Did you understand by pleading true to violation 25 in cause number 2023 CR 0529? The court could grant the motion and sentence you up to 8 years in prison.
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition 25?
Yes, Your Honor.
Court will find violation of condition number 25 and that cause number true. Did you understand by pleading true to violation of condition number 25 and cause number 2023 CR 0531? The court could find it true, grant the motion and sentence you up to 8 years in prison.
Yes, Your Honor.
Knowing that, do you still wish to plead true in that cause number?
Yes, Your Honor.
Then in that cause number, the court will find it true.
The agreement is that you grant the motion and revoke the community supervision and sentence the defendant to 2 years in TDC in both cases. Sentences to run concurrently. And taking that into consideration, Your Honor, the state and defense or the state is submitting a motion to dismiss or reject night mag number 712-695.
That is the agreement, Your Honor.
And what is 712695?
And evading arrest second amendment.
All right, anything you wish to say, Mr. Rodriguez?
Your Honor.
All right, in each cause number, the court will grant the motion, find you guilty. In each cause number, they were one concurrent. And in cause number 2023 CR 0531, there is to be no contact with Hannah and ES. And in cause number 2023 CR 0529, there is to be no contact with. The court will take in consideration night mag number 712, thank you, 695. And in each cause number, there's an affirmative finding of family violence. And in each cause number, the court is going to sentence you to 10 years in the prison, give you credit for any time served.
Your Honor, the agreement was 2 years.
Oh, no, I know. I'm not following that agreement.
Well, then we would like a test hearing. Your Honor.
Court doesn't have to follow any agreement. The court could sentence him up to 8 years in prison. Showing you what's entitled trial court certification of defendant's rights to appeal.
He can only get 8 years, Your Honor.
I'm sorry, 8 years. That's what I gave him, 8 years in each cause
I
number.
gave him 10 years.
No, I gave him 8 years. So it can be clear in each cause number, I'm granting the motion, finding you guilty, sentenced you to 8 years in the prison. The cause numbers were run concurrent. There's an affirmative finding of family violence, no contact with Hannah Barnes. And each cause number, I'm showing you what's entitled trial court certification of defendant's right to appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Right. You do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motions, not the fact that you were on. Because this is a felony conviction, because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney.
Want to say something? Aaron?
Sure.
The reason why I did not take the probation again was because I did try contacting my probation officer, and the reason why I went over there was to get my ID and my social, to get my SSI money to pay for the monitor to be on probation. And I contacted my probation officer, left email, phone numbers. They never contacted me back. I even went in there and they scheduled me a new probation officer. And I was trying to do everything that I was supposed to do.
You're not supposed to have any contact. And I clearly put that in my motions.
And I went to her mother's house to pick up my stuff, and she just happened to be there. So that's why I left. I was gonna be there at her mother's house. I needed that documents to pay for my monitor to be on probation.
Mhm.
I didn't want any of this to happen. And the reason why I took the 2 years was because I didn't want to have to go through all this miscommunication.
Yeah.
Like I went to do my.
Let me just explain something to you. You were on probation
Yes,
for an
ma'am.
assault family second violation,
Yes,
which
ma'am.
means there was a previous conviction of assault family second. And you were also on probation for choking.
Yes, ma'am.
And I ordered no contact. And when I say no contact, I mean no contact.
Yes, ma'am, but I never contacted her.
All right.
I went to her mother's house.
All right. Thank you.